recess at 2:55, subject to call of the chair, because we're recessing on the floor. And then we will and subject to that, the plan would be to reconvene at 4 o'clock. So, I'm gonna skip around, based on some of the things. First, we're gonna go to Senate Bill 2499. That's a simple bill, simply raising the limits of justice court from 3,500 to 5,000. I will tell you, I've had the Circuit Clerks Association reach out to me, so we've been talking with them about that. But if you look at line 11, that's what that does. Do I have a motion? The motion is title sufficient, do pass. All in favor say aye. All opposed? Ayes have it. Is Senator Hickman here? Okay. Senate Bill 2452. I'm going to let Senator Boyd explain this one, but we've passed this one. Is it that much? So we are going to implore our House friends to hopefully do this again in a few ones. But Senator Boyd, you want to explain that one? Senator Parker has pushed this, and there was at one point for whatever reason, it died literally the last day of the session. So we're going to try this again. Okay, any questions? Have a motion, Senator Boyd? Motion title sufficient, do pass. All in favor say aye. All opposed? Okay, we'll call up Senate Bill 2480. The optimum or the language is on lines 27 to 29. This came from the hearings that we had in Judiciary A, where, if you recall, Bob Anderson mentioned to the committee that through the report that came out, they found that intake officers were being used improperly, and they issued a letter saying no DHS employees can be used for intake, because intake is what I call a specialized area, and it's intake, it's not data entry. And so this is simply codifying what they were doing. Senator Boyd, question? Can you speak? I'm sorry, can you speak?
I'm a little confused because I thought one of the things is that we did not want CPS being used as officers either, that should be a function of the youth court to have their own intake officers. So do we want CPS listed in here as opposed just to saying that no state agency employee?
You were right, and if you want to make that amendment.
Okay. All right, I'll offer that amendment that we strike the Department of Child Suppressive Services from that line. And leave AOC.
So you heard the amendment. Any questions on the amendment? Okay, do we have, so we're on the amendment. All in favor of the amendment, say aye. All opposed, the amendment carries. Now we're on the bill. Any questions on the committee, the bill as amended? Senator Blackman.
Thank you, Mr. Chairman. Were we told at the hearing that sometimes this occurs because there was no one else to do it?
We were, and if you have the report, yes. And the reason that it was explained to us was because either county employees were being used or there was understaffing or something to that effect. Also in that hearing, it came out that what is known as the Youth Court Support Fund was honestly woefully being underfunded. So that may have contributed to some of that. But yes, but then there were also DHS employees who were, because DYS is part of DHS. And so they were being used as intake officers.
Will there be, are there enough people to do it now?
The intake part of it?
Yeah.
So we're working on that. So working with Chairman Hobson, we're working to make intake officers pay for officers, but also we've had discussions with the Administrative Office of Courts. Where's Miss Vicky? Yeah, I'm calling you out. So Miss Vicky is overseeing the youth courts at the AOC. The Chief Justice has appointed her to that position. So we are in discussions about how that would work. If it works, then yes, we'll be funding those via the state through the appropriations process.
All right, thank you.
Thank you. Any other questions? Not have a motion. Motion is title sufficient, do pass, committee substitute. All in favor, say aye. All opposed? Okay, that'll carry. I want to skip down to Senate Bill 2483. This comes to us at the request of the Judicial Performance Commission. And in short, it's simply adding the judicial performance to the youth court records, allowing them to have access. Also in the in our hearings, we heard that there is, they needed access so we can have proper accountability going on there. So with that, I'd open it to any questions. Senator Turner Ford, thank you.
Thank you, Mr. Chairman. I didn't have a chance to look. Counsel who has entered an appearance in this, in a youth court case, do they have access to the records without a court order?
Yes, that's been admitted down in that code section, and that's current law anyway.
And the reason I asked is because I was actually told in another matter, well, in a case, that I had to get an order to get records, and I wanted to know.
As you, somebody that was representing a person, well,
Yes.
that ain't, okay, sorry, let me say this. You've highlighted a problem that has been brought up in this situation, that if you read the code section 4321-261 and you go through all there, if you're an attorney, you have a right to inspect those. Now, what has been the case is that different jurisdictions have enforced that differently, even though the law says otherwise. If you're an attorney, and you're representing that, there should be no reason why you should have a separate order to get that. So, but the current law is there in front of you.
Thank you. And I just did not have a chance to review this quickly, but this would have been an opportunity to make that amendment if so needed. But thank you, Mr. Chairman.
Well, I don't want to rush that. Yes,
Line 76.
thank you.
It says the parent, guardian, custodian, or any attorney for such parent shall have the right to inspect any record. And I've heard this same complaint, that some districts allow you to inspect them and some allow you to make a copy of them. So that's kind of been the problem, the rub in my area, at least.
And
If
if
I
you,
may,
yeah, go ahead.
So looking at line 76, it says upon request. So does it need to be clarified that if an attorney enters an appearance, they would automatically have that?
Well, but
right to-
part of, if you see on line 79, it says inspect. So some have interpreted that to say you get to look at them, but you don't get to take them to your law office. or anything like that. I think that's what Senator Barrett was saying. And then some are saying because it's inspecting, then you have to go get a separate order from the judge under this section before you even do it, even though, which is not the case in criminal court, where once you enter your appearance, you're bound by the rules of professional conduct and all of that. So, yeah, if you want to make an amendment.
I would like to,
Appropriate.
offer that amendment, although I don't have the exact location, but,
On line 85,
Okay,
just delete upon request.
okay, thank you. Shall be provided a copy of any record, which I think that was,
Mr. Chair, you see it? Just delete upon request.
so if I may be recognized to offer an amendment.
okay.
I would
Yes, you
move-
are.
Thank you, Mr. Chairman. I would move at line 76 that the words upon request be deleted from that paragraph.
Okay, any questions? You've heard the amendment. The amendment is to delete, on line 76, to delete the words upon request. Any questions on the amendment? Okay. No questions, so we're on the amendment. All in favor of the amendment, say aye. All opposed? That amendment carries. Okay, we're back at Senator Turner Ford.
Thank you,
Still have
Mr.
the
Chairman.
floor.
I think I have another amendment. And so the follow-up amendment, well, a second amendment would be regarding attorney representation of a minor in youth court, that the language upon request would be deleted from this paragraph. I guess starting at 76 over to, well, this section, paragraph 3.
So wherever it, as it only pertains to attorneys or to everybody?
The attorney representing a minor in youth court.
Okay, where, can you restate it or where you're looking at for the,
Further down in that section is, at 85, it states upon request, and I would move that that be deleted also as it relates to the attorney.
okay, you've heard that amendment. Any questions? Would you, I'm asking counsel, he says that can be a conforming amendment.
That would be my motion.
Okay. So all in favor, say aye. All opposed, that carries. Okay, we're back on the, bill. Any further questions? Do I have a motion, please? Motion is title sufficient, do pass committee substitute. All in favor, say aye. All opposed, that carries. Thank you. I'm going to call up Senate Bill 2771 and turn that over to Senator Boyd, revise the timeline of permanency hearings. And this is coming to us, I think, from CPS.
This is one of the bills that we did 2 years ago when we were trying to move children to permanency faster. And at the appropriate time, if you look in line 38 and 39, we are shortening this time to 90 days, but they have requested that at the appropriate time, I'll make an amendment. And they have asked that we say 3 months as opposed to 90 days. So I'd like to make a motion.
Now's to make your amendment.
Thank you, Mr. Chairman. I'd like to make a motion that where it says on line 38, that we say 3 months, and then on line 39, we'll say every 3 months.
You've heard the amendment. Any questions on the amendment? All in favor, say aye.
Aye.
All opposed? Okay, we're back on the amended bill. Senator Simmons.
And so the line that, the language that we changed it in the statute can be found on 38 and 39?
Correct.
All right, so what's the current law?
I think it was 60 days.
Okay, thank you.
What was explained, and we had that, what was explained to us was there are places, it's just not possible to meet those deadlines. And let me say, we had passed the law, I guess that was last year, year before, in the effort to move children to permanency. But we're setting them up to fail in that regard, so that's why we're changing it. Okay, so council, thank you. Well, I guess it was 120 days, and then if they were under 3, it was 60 days. So now her amendment was setting it to the 3 months for everybody.
And Mr. Chairman, if I remember the bill when we considered it originally, it was a concern of the adverse effect it may have on those parents where permanency was actually determined against. And so that's why we were trying to create a longer period of time, because if I remember the debate, some individuals may not be represented by council, they didn't know about it, and then before they actually found out about it, permanency had been determined and they've lost their rights. I think that was the concern at the time. The reason why we extended the time to 120 days. Any concerns or any explanation as to why now we'll actually reduce that down to 90 days as opposed to 100?
Wants to
All right, yeah.
Thank you. When we did these dates originally, it was one of the things that we asked our youth court judges to really help us monitor, like to see what was needed and not needed. And so we made those distinctions, especially about under 3 and that. And they have seen no reason not to go ahead and start looking at these at every 90 days. And they are not automatically ruling on permanency and taking away a child every 90 days. What they're doing is they're looking at the situation. Is there progress being made? Are there significant steps being made? And this helps them manage that. Also, too, having the 2 different time frames was a little confusing as well, because children turn 3 in the middle of it. And so they thought really going down to this 90 days really kind of set a better standard for everybody to kind of know this, but they did not think there would be any adverse effect to the child or to the parent in this process, and thought it would make for a smoother process. So.
All right, we're on the committee sub. All in favor, say aye.
Aye.
All opposed? That carries. Thank you, Senator Boyd. I want to go to Senate Bill 2899. This is, I think everybody is familiar with this issue. This comes to us from our Court Reporters Association, and this is what the bill is doing is raising the salary for court reporters in the state. For those maybe that don't know, we have had a significant issue with court reporters in this of either leaving the profession, not being able to hire them. I think even to the point where the lieutenant governor has looked into what other schools there can be. And I would have myself have an amendment if I'll state that. And my amendment would be where it says may to change may to shall. So in line 8, yeah. So, any questions on the amendment? Any questions on the amendment? All right, on the amendment, all in favor, say aye. Oh, question? I'm sorry, hold on. Senator Simmons?
Yes, Mr. Chairman. So who pays the court reporters? Is that county fund?
Counties are paying them. I think I know where your next question's going.
Yeah, it's just, of course, I mean, as the chairman of county affairs, our supervisors are going to be concerned about an unfunded mandate. They certainly will want to, as a deliberate body, make determinations as it relates to pay raise and as they look at their budgets. But to change that language to shall,
But
can we put a reverse appeal in it?
I understand your
Okay.
point, but we have no I shouldn't say that. We're having a significant problem with court reporters. Judges all around the state are saying they are not getting court reporters. And also through the association, there can go other places and do that and make money and do it in the private sector and all that. And yes, it's been left up to the counties to do that, but they've chosen not to do it in a lot of places. So my amendment is changing that from may to shall, yes. And,
I, I, I just, well, you say in some places, and I can't really speak to those places, Mr. Chairman, but I just know
if you want to do an amendment to the amendment with a reverse repealer, we can,
I'd love to.
objection to that.
I'd love to. Thank you.
Okay. Are you making that?
Yes, sir.
Okay, do we have Senator Hobson? Is the question on that?
Not on the reverse repealer, I'm not. But
Okay.
After that, if that's the motion, if you'll entertain that first, I'll then ask a question.
So we're on the amendment to the amendment, which is a reverse repealer. All in favor, say aye.
Aye.
All opposed, and now we're on the amendment, which is to change may to shall. And you wanted to speak on that, Senator Hobson?
Yes, sir, Mr. Chairman.
Okay.
I really, I don't know, I'm debating whether it's on the bill or whether it's on the amendment. I'm fine with the shall payment. I think one of the problems we've had with court reporters is when court reporters were taken away from the opportunity to freelance when they weren't doing court work, and that is our court reporters, as opposed to just full-time freelance reporters. That opportunity was taken away by the court, by the Supreme Court order or rule, as I recall, about 10, 12 years ago. And I think that was a problem. I don't know what the rationale is exactly as to why that was taken away, Mr. Chairman, but I've wondered, and it could affect the may versus shall, but I have no problem with a court reporter in a particular county or a particular court that is not involved in that case doing freelance work if they have the time to do it. And I think that would help. We do have a problem with court reporter shortages. I know that. We have a problem with their pay. I don't know what the ultimate solution is. Maybe the best thing to do is just offer this shall, and then maybe later on offer something that would allow them, if we can do it legislatively, the ability to freelance when they're not doing that court's work. I would hope we could look at that too, Mr. Chairman. So I'm probably just pontificating more than I am offering a solution at this point. It seems like we've discussed this in the past, and I would love to know if there's been any data that would support that would solve a lot of the problem with the ability to, the pay and their availability of court reporters, which is the second issue.
I would say, as I understand the reason for the rule or the explanation of the rule, that was a result of that, or a consequence of it. But it was a rule, not a statute, and if what you're saying maybe could address that. But I wanted to ask, is Candace here? Anybody from the court reporters? Okay. I thought, but so right now we're on the amendment, and if that passes, we have the reverse repealer in it. I think that's all good discussion.
That's fine. I would ask if you would, Mr. Chairman, to entertain the possibility of an amendment on the floor that deals with the ability for court reporters to freelance in cases where they're not involved. So if they're a circuit court reporter, they can certainly do a chancery matter and vice versa. I don't see the harm in any of that. But I would ask.
That helps if to Chairman Simmons' point, that would maybe help the supervisors address the cost.
It might.
We can start, yes, sir, if the question is to entertain it.
Yeah, but I understand your motion on shall, because I think some court reporters have gotten shortchanged because they don't get paid by their local courts. And sometimes it's one county will pay them their amount, their pro rata share, and the other counties don't, and they get shortchanged, and that's not fair for the court reporters. So I think, I say all that just to, I think a lot of us know that, but educate everybody. I think that's a lot of the issue. My other attorney friends may disagree here on the committee, but I would ask, we can go forward with your motion. I have no objection to it, but I certainly would ask you to keep an open mind to any amendments where we can correct this problem for good.
Well, I would point out to the chairman on line 16, it does say, which is current law, no amount of increase shall be paid from the state general fund. So
Right. I think it's the locals that pay that.
because it is where the courts are happening, so. Okay, so I think we can certainly do that. And with the reverse repealer, I can tell you, I've been in touch with Candace, who's in the association, the Chief Justice, and the Supreme Court. This is an issue for them. So I think if we can get everybody together, we can get something in place on that. So, all right, so we're on the amended amendment. All in favor, say aye.
All right.
All opposed? Okay, we're on the committee substitute. Any other questions? Motion's title sufficient, do pass committee substitute. All in favor, say aye.
Aye.
All opposed? That carries. We will, since it's almost 3 o'clock, we will recess and we will reconvene at 4 o'clock. Senator Simmons?
Mr. Chair, may I ask one question before we leave? The third item on the agenda, Senate Bill 2499, on the actual agenda, it has RR behind it, but the bill that's in the packet.
That's right. It already passed. There was no reverse repealer in it. That usually stands for reverse. It's already passed the committee.
Okay, without the reverse repealer. Okay, thank you.
All right, we will recess until 4 p.m.